Good morning. This is Aaron Saladay, the Chair of the Colorado Mortgage Loan Origination Board. Today is November 20th, 2024, and it is 9 a.m. This is a public meeting of the Colorado Mortgage Loan Origination Board. We will now call this meeting to order. Let's begin by having the Division Director perform a roll call.
Aaron Saladay.
Here.
Shirley Thielen.
Here.
David Williams.
Here.
Natalie Lawson.
Here.
Josh Brodbeck.
Here.
You have a quorum.
Thank you. First, we're going to start with approval of the September 18 minutes. Do we have any discussion, or did everybody have a chance to review them?
I'll make a motion to approve as submitted.
I'll second.
All right, there's been a second, and so no discussion on that. Okay, so there is a motion has been seconded and approved to September 18, 2024 minutes. All of those in favor say aye.
Aye. Aye.
All of those opposed say no. All right, we have 5 in favor and the motion passes. Next up, order of business. Looks like we will have the Division Director work on this for us. And are you there, Marcia, to help us out with that?
I am here. So the only thing that you have as a policy matter is the meeting dates for 2025. And this isn't something for you all to vote on. It's just to give you kind of a heads up for your schedules. So the next item, is there anything that you would like on your agenda for the next meeting in January?
Nope.
Nope.
Nothing for me.
Okay, that's it for policy matters.
All right, thank you very much. I'm just checking, do we have any public comment? Do we have anybody that has identified themselves as wanting to speak in front of the board?
Anyone from the public, if you would like to address the board, please click the raise hand icon in the Zoom software, and we can unmute you. Board members, I'm not seeing any hands, so we'll hand the buck back to you.
Awesome, thank you very much. All right. So now we're just on to complaint matters. And I'll turn this over to, is it Sarah or Nicole?
Good morning, it's Nicole.
Good morning, Nicole.
The first complaint matter A, is complaint number 2024-1034. On June 7th of 2024, the compliance manager for the respondent's company self-reported that the respondent originated a total of 15 loans between January 1st, 2024 and May 14th, 2024. During this time, the respondent's Colorado Mortgage Loan Originator license was expired. Of the 15 loans, only one closed. And possible violations include 1210-704, license required, and 1210-713-1M, any Part 9 or rule violation. And we have disciplinary recommendations as diversion and a $500 fine. And Investigator Martinez can answer any questions.
Thank you.
So
we'll open this up to this. Oh, go ahead.
Sorry. Does he have a current license?
I don't believe he's, let me double check for you, but I don't think.
Oh, wait, he said he was working on the fingerprint, so highly unlikely.
Yeah, and I don't know if that's changed since we did our interview, but let me check for you. I don't believe it has, though.
His license is still pending.
Yeah.
Okay.
Yeah.
I have a question. Paul, I have a question. With the one loan that did close, were there any issues with that loan?
We didn't identify any issues with the loan file. Didn't speak with the borrowers, but we didn't see anything of concern in the file. No.
Okay. I have one other question. This is more subjective in nature, but I'm just not familiar. Is there anyone, maybe even a board member, that can give me an idea of how prevalent these high volume online mortgage originators are, where they've got loan originators that are licensed in multiple states that are taking 20 or 30 applications per day. Can someone give me an idea of how prevalent that is?
I think in
I don't have
Colorado,
any experience.
about 80% of the mortgage loan originators, if I remember correctly, are out of state. So most of them have multiple licenses. And I think I had asked Marcia this, or I'd asked this similar question to this several times ago, just to kind of figure out what that looked like with it. But yeah, it seems like most people in Colorado have multiple licenses. If
And
that
a
answers
lot
your
of
question.
these internet lead generation type mortgage companies, I mean, these people are, applying online or clicking on some link. And so the loan officer literally could be, shuffling through, 15 to 30 deals a day, trying to get through the information that they're getting on. So it's a little crazy.
Mhm.
And Paul, was this particular licensee, is he a resident of Colorado or no?
No, he's not a resident of Colorado.
Okay, all right, thank you.
You're
That's all I had.
And then one other question, Paul, is there any way to track if he did start the fingerprint process? It sounded like he was in the process of getting his license done. It just hadn't been completed.
Yeah, so here, I think we may be able to access that in our licensing system.
And to be clear, was this a temporary license that he was supposed to be doing work under a licensed individual while he got his application?
No, he was actually licensed previously and it had expired. Unbeknownst to him, what he had stated was that because of the fact that he had so many licenses in other states, around renewal period, his email box became flooded with the correspondence from all of the states, and it sounds like ours was not immediately identified. So they didn't catch that his license had expired until May of this year. So. And then on the fingerprints, okay, so I'm not showing that we've received new prints yet. Let's see if there's anything in now.
I'm not seeing that he has fingerprints with us yet.
Yeah, I'm trying to log into our CBI, but it looks like the VPN settings here at the office are not allowing me to immediately access it.
Well, it was a bit confusing too, because the mortgage company said that he was going to be submitting fingerprints, but in his interview, he said he had submitted them.
Right.
So it seems a little fishy, actually. My opinion is that if you have to be licensed to do something, you should be responsible for your licensure and making sure that it's current. And I understand they're licensed in a bunch of different states, and the tendency would be to throw it to the company that you're working for and have them track it. But I think there should be some self-responsibility as well. Will you remind me what diversion is as far as disciplinary action goes, please?
Let's see here.
Basically, it's a stipulated agreement that it has language in it that says that once the terms of the agreement are completed, it will be considered a dismissal, but it's a matter of public record.
Okay, thanks.
Shirley, I happen to agree with your analysis. When you're part of a licensed profession, you know whether or not you have an inactive license at any given time. The fact that you're licensed in multiple states, I don't know, minimizes the importance of that. My sense is that, for what it's worth, I'll throw it out to the board. I'm okay with diversion, but I'm not comfortable with a $500 fine. I would be more comfortable with $1,000 fine. And then we could leave diversion. That's my personal feeling.
And board members, I do see record of his 2024 fingerprints in the NMLS registry, just not showing in our individual licensing system, but they are showing in the NMLS registry.
Does
So
it
he
show what
has to
date that he did
Yeah,
that?
October 17th is
Okay.
when they're showing as received in the NMLS registry.
And was that, well, that was prior to his expiration, then he was moving forward, right? Or no?
That was after his expiration. So
Oh, okay.
yeah, he expired essentially December 31st of 2023. So it's the period between January and May that the loan applications in question were taken.
Do we
Well,
know?
Josh-
Oh, sorry.
Go ahead, Aaron.
I was just gonna say, do we know if he's taken any more applications in Colorado since?
No,
the-
both he and the compliance manager confirmed that in May when they spoke with him, everything ceased.
Okay.
I agree with Josh that I would like to see a fine of $1,000. Because I do expect a professional to be tracking their own licenses.
I kind of feel the same. I'm in watching the interviews. The company was actually talking, and they kind of seemed a little surprised as well that it wasn't an annual policy versus a term policy. You know, that
Yeah.
they thought it was going to go through October again, if I remember correctly. So I think there was a lot of misinformation between the two of them. So I would definitely be in the same spot there with the diversion and $1,000. Dave, what do you think?
You know, I guess, 1,000 seems a little steep, but, it sounds like, he just lost track. I'm not saying that's a good thing that he lost track of what he had going on. Apparently, the company wasn't on top of it either. So it seems like there's, two parties here to kind of keep you on. I know at my company, they're all over us and will send us notices if you don't have your, renewal coming up. So.
Okay.
Yeah, I also find it curious that, okay, he was notified in May to stop doing Colorado loans, but it's taken until October for him to get his, to get into action as far as getting renewed goes. So I think that's a little curious that,
Yeah.
I would have said, oh, shoot, I better get right on this, but he did not.
Yep, absolutely. Any other discussions? Would someone like to make a motion?
Sure, I'll make a motion that we go ahead and accept staff's recommendation of diversion and increase the fine to $1,000.
Do I have a second?
I second.
Now, do we need to, a question real quick, do we need to quote the violations with that?
No,
No.
you're good.
We're
I
good?
think. Yeah.
Okay. Okay.
Yeah. I would,
All right.
I would just to be complete, I would just out of an abundance of caution.
Okay,
I don't think it's necessary, but just out of an abundance.
all right. Would you like to add those, or are you okay with just doing it that way and then making a second?
I can restate if that's helpful. I move that we accept staff's recommendations of diversion, however, a fine of $1,000 pursuant to section 1210-704 and 1210-713-1M as in Mary.
Do I have a second?
Second.
All right. All right. I have a motion and a second. Would like to take a vote. If those in favor say aye.
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 And I am also an aye. Those that are in opposed say no. All right. This passes. Thank you, guys.
The next complaint matter is B. It's complaint number 2024-897. A complaint concerning the respondent was opened by the division after viewing the CHBG website during investigation of complaint 2024-251. The respondent's phone number is listed on the website CHBG, which appears to be advertising mortgage services without the proper licensing information disclosures. The NMLS ID listed on the website does not trace back to any licensee or company registered in the NMLS. The site also lists Celebrity Home Loans, which has been dissolved since February of 2023. The respondent's Colorado loan originator license expired December 31st of 2023. The respondent is currently licensed with a federally chartered bank. However, the bank's NMLS information is not listed on the CHBG website. As of the date of this report, the respondent has failed to respond to the division's notification letter, final notice to comply, and any phone calls. Possible violations include 1210-713-1M and Rule 5.1 advertising. Disciplinary recommendations, we have cease and desist, and Investigator Martinez can answer any questions that you might have.
Thank you very much. I have a question for you, Investigator Martinez. Was there any communication with him since you reached out, the emails or anything? Nothing at all since?
So I did notify him. Well, the email addresses that we have on record, I did send them saying, "Hey, we're presenting this to the board." I haven't heard anything back. Interestingly enough, the phone number that's listed on the website, I called several times through the course of the investigation. Obviously, our number comes up as Colorado Department of Regulatory Agencies on a caller ID. However, there was no option for me to leave a voice message. If you listen to the recordings, it's full every time. So I was not able to speak with him. No.
All right, thank you. Any other discussion about this, guys? It's pretty clear cut to me. If there's no communication, obviously there's a license that needs to be required, everything's expired. It's pretty clear cut to me.
Can I ask just one quick question? Are those sites still active or have they been taken down?
Yeah, the website is still active.
Wow.
Still lists the same information. So yeah, it doesn't appear that there's been any movement on the site.
Yeah, and it's clearly his email address. And I mean, it looks like he put the website up and it's just left it there.
Right.
Yeah, it's possible that it may have been something that was done years ago when he made the transition over to the federal license. Just kind of yeah, like you said, let that slip. But the concern there is that there's no state license and it doesn't give any disclosure for any of the federal bank information.
Right. And his license is expired.
Yes.
So if he were to, okay, so if we were to go with recommendations, and he were to apply for a Colorado license, would any of this show up?
I think if the cease and desist were agreed to by the board, that would be public, if I'm not mistaken. But then I would imagine that when his application for state licensure comes back, if it does come back, they'd probably look at the conduct and try to see if he had corrected it or removed the website since.
Yeah, that was really my concern, is if we agree to a cease and desist, because we really don't have any other choice because he's not licensed. Would that is that a public record? And you answered that question. Thank you.
One of my
Definitely something that
concerns.
you all would see.
I'm sorry,
You
Marcia,
open-
what?
It's definitely something that when an application is submitted, you're going to be privy to more information than the general public would.
Yeah.
So with the cease and desist orders, depending on the program, there's some ambiguity as far as what is public record and what is not, but you would definitely see this come back to you as an application.
Okay, perfect.
Thank you. One of my concerns with the cease and desist is we couldn't get a hold of him in the first place. How would we actually, I guess, get in touch with him and make sure that he understands that it is a cease and desist? Obviously, we email, we mail, we try and call, but if he didn't respond to us this time, how would we know that he would actually receive it?
So those just get mailed to the respondents. Whether they take note of it or not, I mean, that is something that a second time around, if we have a violation where he's violating your statutes, we may do something more than a cease and desist and look at doing an injunction, which is more involved than just getting a letter from the board in the mail saying stop what you're doing.
Yeah, absolutely. Okay, thank you.
Aaron, I had the same thought as you. Clearly, we're not getting any responsiveness from this person. We don't even know if they know that we're trying to reach out to them. So my thought was, obviously, we don't have a choice but to issue the cease and desist. But I would also like to attach a fine to it so that if this person were to, not that I expect this person would ever even find out about the fine, let alone pay it. However, if they did try to reapply for a license, they'd have a fine waiting there for them. That would definitely get their attention that time around. So I was planning to recommend to the board that we levy a fine of $1,000 with the understanding that they may not ever find out about it or pay for it unless they apply for a new license.
I think the problem with that in the past is they don't have a license. There's no teeth to it. But I kind of like the thought process that if they did want to do this, obviously we'd see the cease and desist and there would be a fine associated with that. Is that something that we can do, guys?
I don't know in the past that we've assigned a fine with a cease and desist order. I know that the board has fined people in the past, though, for practicing without a license. And it usually carries, in the past, it's been $1,000 fine.
I like that idea.
I do too.
I mean, I agree. It's probably not going to get paid, but to have it as part of the record, I think that's a good idea.
Yeah. Anybody else? Natalie, Dave?
I'm good with that.
Yeah, I'm good with that.
All right. Does anybody want to make a motion?
Sure, I'll make a motion that in reflection of the violations contained in the complaint of 12-10-713 1M as in Mary and violation of Rule 5.1, that the board accepts staff's recommendations to issue a cease and desist and add a $1,000 fine.
Do I have a second?
I second.
Second that.
All right. Let's take a vote. All of those in favor, say aye.
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 I am also
Aye.
an aye. All right. And motion passes. Thank you.
The next is matter C, complaint number 2024-251. Between January 1st and January 10th of 2024, the respondent advertised mortgage loan originator services on his social media page while not having an active Colorado mortgage loan originator license. Some of the advertisements quote interest rates and down payment amounts and do not list the respondent's NMLS ID or any company information. Additionally, the complaint alleges that the respondent failed to include required disclosures in advertisements that contain triggering terms. It was identified that the respondent became an employee of a federally regulated entity on January 11th, 2024, and is now exempt from the state licensing requirements. The respondent's reapplication for a Colorado mortgage loan originator license is currently pending. Possible violations include 1210-704, license required, 1210-713 1EE, any advertising of residential mortgage loans, and Rule 5.1 advertising. Disciplinary recommendations include diversion and a $250 fine, and Investigator Martinez can help answer any questions.
Thank you. I'll open this up for discussion.
My biggest issue with this guy is just the deception to the public with the way he was doing his social media and stuff. Very dishonest in his approach to trying to, position himself as somebody that he really wasn't. And from an ethical standpoint, I have a big issue with that.
Absolutely.
Paul, I do have one question. I know that this person's license renewal is still pending. Is it still pending or,
Pending the outcome of this complaint.
okay, all right. So this is the only thing that's holding up the disposition. Okay, understood. Dave, I'm not only am I concerned for the same reasons you are, but what further concerns me is that when this respondent was interviewed, they made false statements about who their employer was. Then they made false statements, if I understand right, that their employer was a division of the larger institution that had the license that he said he was operating under. And then made false statements that who he stated was his employer was actually registered to operate in Colorado. And all of that happened in the same interview. And these to me just don't seem to be things that you would mistake. I think we all kind of know who our employer is, and then whether our employer is a proper or improper subsidiary of another company, and then whether or not all of that is licensed to operate in Colorado. It would seem to me that we would all know that. So I'm with you. I'm really concerned about the misrepresentations and the knowing false statements. I realize this person has had some personal hardships, but we've all had personal hardships, and I don't think that compels us to lie about really important things. That's my sense.
Thank you. Shirley, Dave, anybody else have anything else to say about it?
No, sorry.
It's to me, in these cases, a lot of times one thing will unshroud something else. And in our last meetings, we actually, I think this may be one of the ones that we want to do this as well, where we say, hey, I think this is bigger than us as well. So this may be something that we would want to recommend to have some agency review Source Mortgage and Mortgage Group and Novus to make sure that we've got everything, taken care of. Because it seems like this is not just an isolated incident.
Paul, have there been any past discipline issues with this person under, well, actually for anything with respect to the division of real estate?
No, I did not see previous record of discipline, but let me also check the NMLS. Oftentimes, if there's discipline in another state, the NMLS will have it before our system does. But let's see.
Okay.
Thank you.
Thank you. That would be helpful to know.
Okay, board members, as of right now, there is no record of disciplinary action in the NMLS registry for this licensee.
Thank you. Any other discussion, guys?
For what it's worth, my read on this is that I don't think diversion is enough. I think that a final agency order is sufficient for this situation, particularly since we know this person is seeking renewal. And with that, I'm not sure that a $250 fine, particularly given the fines that we've already decided upon today, would be sufficient either. I think $1,500 would be fair. That's my recommendation.
Can someone tell us and remind us what the actual final agency order would be for them?
So final agency order is permanent record, and basically it shows up on the website. It's subject to open records requests, but if you search somebody on the website, it's going to show up that they had a final agency order. And then if you add public censure to that, basically It also goes into our newsletter and also on a different area on the division's website, along with our licensing database.
Thank you. All right.
I
Any
have
other
one last
discuss-
question. If he is working for an agency, federal agency or federal company that doesn't require him to have a Colorado license, to be individually licensed, does he still have to have E&O insurance? Is that required? Because he doesn't have that either.
Under the federal license, I don't think the state requirement would apply. Our specific requirement
Got
for
it.
shared E&O.
Okay, okay. I agree that in light of especially the fines that we recommended for the last two cases, 250 is too low. I would recommend a fine of 1,000 and I'm good with final agency order.
Anybody want to make a motion?
Sure, I'll make a motion that, in reflection of violations of 12-10-704, 12-10-713, 1EE, and Rule 5.1, the board go ahead and issue discipline of a final agency order and a fine of $1,000.
Do I have a second?
I second it.
All right, let's take a vote. Although in favor, say aye.
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 And I am also an aye. The motion has passed.
And board members, sorry to interrupt, just for a point of clarification, is that just a final agency order or is that a final agency order and public censure? They are two separate things.
I'm
The
fine with the
motion
final
was just
agency.
for a final agency order.
Okay, just wanted to confirm that's what you wanted. Thank you.
Thank you.
Thank you.
All right. And looks like we don't have any licensing matters, but we do have an ESP matters. I'll turn this over to Penny Elder at this point.
Right. Good morning, everyone.
Good
This
morning.
is a little bit of an unusual case to bring before you. You saw this case. This is complaint matter 2022-2191. And you made a determination of a violation and you asked for a stipulation for diversion and a restitution in the amount of $2,000. And the licensee was cooperative, signed the agreement, and has made attempts to pay the restitution. And the complainant is not willing to accept that because they don't agree with the amount. And I think that part of this, the conversation, and I have reached out to the complainant as well and had a conversation, and they acknowledged that they understand that the real estate broker had part culpability in this as well, but given that that was a friend, did not want to hold the real estate broker responsible and wants to try to recover the entire earnest money amount from this licensee. There is a pending civil case that is at play over this amount, and I do not have a status update on that. I think it is still pending. But this particular licensee is just reaching out to me, wanting to comply with the board's order, takes it very seriously, but doesn't know what to do when the individual is refusing the restitution payment. So I have not had this experience before, so I'm not really sure how to advise the board, and I don't know if the board's attorneys have any recommendation, but I'm just bringing this to you because technically this order still has not been complied with. And rather than just leaving it kind of lingering, I thought I'd bring it back to you for discussion.
Thank you, Penny. Are there any recommendations from the council?
Not It is as Ms. Elder noted, a very strange situation. We don't necessarily have any recommendations on what to do. Some potential paths forward is to modify discipline if you think that's appropriate, to either remove the restitution or change it into something else. Um, Given that it's not being accepted, it is hard. You can't force somebody else to take money from you. So that is one path. If the board is looking for alternatives, yeah.
So is it possible to put the money in escrow? Does the state have anything set up for that? Pending the result of the civil case, obviously.
You know, again, I have not dealt with this situation, and I may ask Marcia, not to put you on the spot, but if you have any experience with this, the state doesn't usually. We try not to be in receipt of those funds, and we look for proof for the funds to have been delivered to the appropriate party. So I don't know that our accounting mechanisms easily allow us to sort of hold on to anything. And so, yeah, I'm just not sure what.
Yeah, I don't think we can hold money for others.
Okay.
Statutorily, I don't think we have the ability to do that.
Surely, I had that question too. I was wondering if there was any way we could impound it, but I'm hearing no.
Yeah.
Could we do a deferred judgment that takes effect upon the settlement of that civil lawsuit?
You could, I guess, hold the case in abeyance. The board has already reached a initial disciplinary recommendation. But I think part of why we're here is to move this case forward, and placing it in abeyance until the civil suit elapses could take quite some time. And as you know, Ms. Elder noted, the licensee is trying to comply with the board's order, so it could just lead to a little stress for that individual. One possible thing is we could have a resolution that reflects that restitution was ordered and accepted by the respondent, but refused by the recipient. That way it shows, you know, kind of respondent acknowledged that he was willing to do this, and, you know, accepted this discipline, and you know, tried to comply, and it just didn't go forward as a potential outcome.
I had a couple of clarification questions, either for Anthony or Penny. Is the fact that that his compliance has not technically happened yet, is that holding him up professionally somehow right now, or is he still able to originate loans and so forth without interruption?
You know, that's a good question, Josh. I think that it certainly doesn't affect his ability to practice. However, the language in the stipulation, you know, says upon completion of the terms, this matter is, you know, any further disciplinary action is dismissed. And so potentially this does hold it open longer for him and cause him to make different disclosures with other jurisdictions about a pending disciplinary action, or you know, something, because it is holding it open. Once he complies with the terms, the matter's dismissed. And so although it doesn't affect his ability to practice, it could affect his, you know, how he answers or responds to other jurisdictions' questions about actions.
Okay, that makes sense. The other question I had is, do you know for sure that when this respondent has attempted to make payment, that he has not tried to do that attached to any kind of a disclaimer that would be releasing him from the civil action. Because I don't know if you've ever seen that, but people try that, right? They'll try to submit payment and then they'll attach to the payment or some kind of a disclaimer that says, essentially, if you accept this money, you're releasing me from all other actions. So I was thinking that might be a reason why this person is not willing to accept money from him, but I don't know that for sure.
You know, I am very sure that that has not occurred, and I spoke to the complainant myself because the respondent was trying to obtain a new address for the complainant and was unsuccessful getting them to respond. So I spoke to the complainant and simply asked for an address so that I could help as the conduit to get the check delivered. And they just absolutely refused, said, nope, they don't want to accept partial. They want the whole amount, or and I think that the complainant is concerned that receipt of partial may affect theirs. I don't know. I don't know for sure.
Right.
But no, that it was my understanding in my conversation with both the respondent and the complainant that there wasn't anything attached. And, you know, frankly, the conversation with the complainant did involve the discussion and the acknowledgement that the real estate broker was culpable for managing the dates and responsible as well for the loss of the earnest money.
Yep.
But given that it is a friend, doesn't want them to have to pay, even though according to the complainant, the respondent or the real estate broker made an offer to pay partial. So it feels a little bit like somebody trying to I won't opine on any intent, but I do know that the licensee in this case has in good faith been trying to pay without any strings attached, to answer your question.
Okay.
And just to further ask one more question, actually piggybacking Josh, with that, if it's still open, will that affect, I think my answer is yes, but will it affect his 2025 renewals with this thing being open?
Again, I don't believe it's going to have an effect to prevent a renewal, certainly for us, because we're aware of the circumstance. But if they were renewing in another jurisdiction and had to answer the question of, is there a pending disciplinary action or is there an active, it could complicate their life in that regard because it is still an open matter.
It really kind of ties our hand as a board if we hand out discipline and then someone doesn't accept it, and then really now it's put back on the respondent that, hey, no, it's really, I could see this really affecting him, and even though they don't want to have culpability with friends or whatever, that's still not the case of it, So I think it definitely ties our hands with how the complainant's handling this for sure.
If we had an ability to, and again, I look to Anthony for guidance on this, if we had the ability to somehow close this matter with some acknowledgement that the attempt to restitution was that the respondent attempted to make payment and it was refused, and if we can close it, then I think that there is still the open civil matter and these parties can resolve that issue in that venue. But in terms of his obligation to the board, he did attempt to meet that. Part of the stipulation that he did sign does say that this is resolving this issue in total. And so to add any kind of additional requirement onto that, I'm not even sure that we can do that because he's already sort of agreed to, this being the total resolution for this matter.
So if we were to do some kind of amendment under the circumstances, what do you think the odds are of having the complainant sign something saying that they declined the payment? I would really like to see that included in this.
I could attempt that. You know, they were, I can attempt that, but I certainly can attest to that. But I'm not sure that I can get that in writing from them.
Hmm.
I hear you, Shirley. My sense is that the board has already tried to involve the complainant by trying to help them out. And the complainant won't accept our help. So further involving the complainant may not be, that may not get us anywhere closer to resolution, is my sense.
That's a good point.
I agree with that. I think what we should probably do is probably amend it, if we can do that, take the fine away, and since she's moved it to civil court, we do the diversion, if that's how we end up doing it, and just take the fine away and then let them battle it out, because we've done what we can do. If she won't accept it, then there's nothing else that we can do, really.
Right. Yeah, I mean, I think that's true. And I remember this pretty clearly. The real estate agent had definitely responsibility in this whole thing.
Absolutely. Yep.
It is not the mortgage brokers. I mean, yeah, they're stuck. You know, it's
Yeah.
not, well, whatever. We'll let the civil case decide that. But I agree with you, Aaron. I really think we don't have any choice, honestly.
Are we able to amend what we had before, Penny?
Again, I'm looking to Anthony on this. I don't think we can add additional sanctions given that they already agreed to this, but I think that we have the ability to amend the order to say something along the lines of, you know, the respondent in good faith made efforts to pay the restitution, but it was refused. And I could work with counsel on what that looks like, unless counsel doesn't want to take that on.
Happy to help always. And yeah, I can't say it any better than what Penny said. Yeah, I think some sort of language saying restitution was ordered, was acknowledged and agreed to by respondent. The recipient refused restitution payment. Therefore, the board is removing restitution from its initial sanction. Some language like that we could craft in, and definitely can work with Penny to get something that kind of conveys that notion.
Can we make a motion for Penny and you to work on that motion for us? So it'd be all good? Okay. All right.
Yeah, I think the clarity is that, you know, we don't want to pursue a stip violation of this order, but that we'll work to close the matter, acknowledging the attempts to comply with the order.
Perfect. Okay. All right. Does anyone, would anyone like to make a motion?
I do have a question about a motion. Can we just dispose of this today by simply making a motion that the board believes that the stipulation has been satisfied, with the caveat that respondent attempted to make payment and it was refused? Can we dispose of it all today, or do you and Anthony need to draft a motion that we would then vote on at the next meeting? How does this work?
I think that what you're saying is appropriate, and then Anthony and I could work together on how we memorialize that for the file, so that down the road, when some of us aren't here, there's at least an explanation as to how this played out, so that there's a record.
Perfect.
But I think you're correct that that's the board's, if that's the board's decision, is that you're willing to close this matter based on an attempt to pay, and then we'll just figure out how to memorialize that for the record.
Perfect.
Okay, so I will move that that the board declares case number 2022-2191 as closed, in reflection of the fact that the stipulation attempts to satisfy the conditions of the stipulation have been made to the fullest possible extent from the respondent. Does that suffice?
I believe so.
And then I would probably add to have Anthony and Penny work on verbiage for that.
Amendment accepted.
All right, all right.
I second all of that.
All right, we have a second. So let's take a vote. All those in favor say aye.
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 And I am also an aye. The motion passes. So thank you, guys.
Thank you.
All right.
Thank you all. That's all I have for you today.
Thank you very much. Looks like there are no attorney general matters. And no executive messages. So are there any agenda items for the next meeting that we may have? All right. Well, I guess with that, I want to say thank you, everybody, for meeting. Thank you all for your time, and especially to our investigators. I know it takes a lot for you guys to do that. So thank you very much. I guess our next scheduled meeting will be January 15th, 2025 at 9 a.m. And based off that, we'll do an adjournment.
Thank you,
Motion
Aaron.
to
and Have
adjourn.
a
Thank
great
you all.
holiday, everybody.
Yep,
You
thank
too,
you.
Happy
everybody.
holidays.
Thank you.
And
I think
the
we may
first
need
time
to
Happy
vote on
New
the
Year.
adjournment.
Oh, vote on the
Oh,
adjournment.
oh, definitely,
I
okay.
think I believe that's what the normal practice is.
Okay. Can I make a motion to adjourn?
Second.
All right. All those in favor say aye.
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 All those opposed say no. All right. The matter passes. Thank you all. Take
Thank
care.
you. Bye, everybody.
Take care, everybody.
Happy New Year.
Thanks.
Thank
See you
you.
next
Bye.
year.
Have a good holiday.
Bye-bye.